All right, let's go to the ANZ and Suncorp, where the Australian Competition Tribunal has dramatically overturned a decision of the competition regulator, the ACCC, and has greenlighted the ANZ's $4.9 billion takeover for the Queensland-based Suncorp. Now, a final decision now rests with the Treasurer Jim Chalmers. He's a Queenslander, remember, and also potential court challenges that could come from rival banks. The decision also highlights calls by the ACCC for significant reform to merger and takeover law in this country. I spoke with the chair of the ACCC, Gina Cass-Gottlieb, a little earlier this afternoon.
The Australian Competition Tribunal has authorised the merger of ANZ and Suncorp Bank. What is in common is that the tribunal has identified that we do have in a major national Australian financial services market, the national market for home loans, the market conditions which are conducive to coordinated behaviour, not least because of the 72% market share in terms of banking assets held by the four major banks. And in addition, because there continue to be barriers to entry through higher cost of funds, for example, difficulty to access and afford new technology platforms that are faced by smaller banks. So there are key factual findings that are the same as ours.
But you come to a different conclusion. You say it shouldn't go ahead, they say it should go ahead.
Correct. The ACCC was not satisfied that we could be sure that there would not be a substantial lessening of competition in three key markets in relation to agri-banking in Queensland, in relation to the banking for SMEs in Queensland, and also in relation to the national home loan market. And we were concerned in relation to home loans, looking at the very high market share of the majors and oligopolistic market structure, and in effect, the capacity for cosy behaviour.
But you have a right now to go back to the federal court and to challenge this, while the Treasurer himself is making his own decision about whether this merger should go through.
There is a separate decision and a separate process for the Treasurer under the Financial Sector Shareholdings Act. There is also legislative processes in Queensland still to take place. There is a possibility perhaps for Bendigo, which also had joined the proceedings, to oppose the authorisation to consider going to the federal court for judicial review. We are ourselves reflecting upon the decision.
OK, so can I ask another strange question here? You had recused yourself as the chair of the ACCC from making comment on this matter right the way through because of your previous dealings as a lawyer, as a commercial lawyer. Why now are you speaking?
I did not participate at all in the deliberations on this matter. However, we reached a decision. I stand by the process in that decision. And what is important now is to look forward at what is a very important administrative decision-making process, which is merger authorisation. And in addition, we have put a very critical proposal for reform to the informal process, because currently it is entirely voluntary whether parties notify a merger to the ACCC. The review by the Treasury Task Force has shown over 1,000 mergers occur each year in Australia. We see roughly 350. So we see less than 1 in 3.
So the reason you're speaking out now is because of that merger reform, because you are urging, and the ACCC is urging, change in the rules when companies are taken over or when they merge.
We are urging a fit-for-purpose merger regime in common with the vast majority of OECD nations, which will be an administrative process with set timelines, with a fast track for the vast majority of matters which will not raise issues, that will allow, in common with this process, that we have seen in this matter, the checks and balance of a review in the tribunal, so that parties have both the obligation to come into the ACCC, to be considered, carefully investigated by the ACCC and reach a decision, and then the right to have a review in the tribunal, so with a full check and balance across that administrative process.
Because what you're saying in this case, but in many other cases, that the merger is announced, the takeover is announced. You only find out when it's announced, whereas you'd like to be involved earlier in the procedure to make certain that the merger should even get to the point of, whether it's announced or not?
Our first point is that we want to make sure that it comes on our radar at all. It is a first important point to make. We had the example just before Christmas with Petstock that the owners had amassed the second largest chain selling specialty pet products in Australia with no notification whatsoever in a whole series of acquisitions to the ACCC. That was resolved on the basis that over 40 stores are being divested and 4 veterinary hospitals. So it was seen that there had been a real issue that the ACCC had raised. So step one, we need mandatory notification, and that the parties cannot proceed to complete until there's been an approval by the ACCC or the tribunal. Step two is we do want to make sure that it's a process that incents the parties to come forward, to bring all the necessary and helpful information forward early so that we are able to conduct that investigation and consideration and assessment properly informed to make a decision that does balance and achieve the outcome in the public interest. At the moment where we don't see and we don't have fit-for-purpose powers, what is at risk is the consumer interest in continued choice and lower prices, small business interest in supplying to increasingly concentrated processors, purchasers, etc. Farmers'
so I was going to ask you about
in
that because is that really where it comes down to? This should be viewed through the lens of pricing, of inflationary pressures. So in other words, if there's concentration, be it in banking, be it in supermarkets, be it in pet food, all of those things have an outcome in terms of inflationary expectations, price controls in this country.
They do. So a number of important points. There has been work by Treasury and others that has shown that across the economy where there's increased concentration, it is correlated with higher markups. So we see the pressure towards higher prices. It is understood in traditional antitrust economics that when you have less competition, you have less downward price pressure, you have less choice, you have less competition on service. So in these circumstances of high inflation, more cost of living pressures, we are aware that many of the transactions and mergers that have been most closely scrutinised and of concern to the ACCC are those directly relevant to cost of living pressures for households. So they relate to banking services, they relate to food and grocery, they relate to petrol prices. So these are ones that are critical in the cost of living pressures and are good examples of why we need fit-for-purpose powers and reform.
Gina Cass-Gottlieb, always good to chat to you. Many thanks for your time.
My pleasure, Ross.